This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Now kindly simulate the first paragraph at page 46. এত দ্বারা আপনাদের জানাইতেছি যে গত ৩রা মার্চ যাদবপুর বিশ্ববিদ্যালয়ে পুলিশ এবং তৃণমূল আশ্রিত দুষ্কৃতির তাণ্ডবের বিরুদ্ধে আমাদের ঘোষিত কর্মসূচি অনুযায়ী বিদ্যাসাগর বিশ্ববিদ্যালয়ের গেটের সামনে শান্তিপূর্ণ কর্মসূচি চলছিল। এই কর্মসূচিতে বিদ্যাসাগর বিশ্ববিদ্যালয়ের সামনে অতর্কিতভাবে পুলিশ আমাদের উপরে চড়াও হয়, দিস ইজ মিলার আউটসাইড দি পুলিশ স্টেশন, এবং টেনে হিচড়ে গাড়িতে তোলে এবং গাড়িতে ক্রমাগত আমাদের বুট দিয়ে লাথি মারতে থাকে। এই সময় আমাদের সাথী সোয়েন্সো ঘাড়ে সজোরে আঘাত করে, ফলে সে সংজ্ঞাহীন হয়ে পড়ে। বহুবার চিৎকার করে জল চাওয়া সত্ত্বেও জল পাওয়া যায়নি। আমাদের টেনে হিচড়ে গাড়িতে তোলার সময় বহু পুলিশ কর্মী আমাদের গায়ে হাত দেয়, এমনকি সোয়েন্সো পর্যন্ত হাত দেয়, জামা কাপড় ছিঁড়ে দেয়। This entirety of this allegation is not mirrored in the judicial pleadings which I have read. These are mirrored embellishments which are coming later on. Then mirrored chuler muti and etc. I skip over. Then kindly take page 47, the first paragraph. একজনকে রেখে বাকি 3জনকে লকআপে নিয়ে যায়। নিয়ে যাওয়ার সময় অশালীন কথা বলতে থাকে। এসআই লীনা মাহাতো, নেম the surname is very important. লীনা মাহাতো আমার জাত নিয়ে কুরুচিকর মন্তব্য করে বলে, সোয়েন্সো নিচু জাত, তোকে এত সাহস দেয় কে? ছোট জাত, ছোট লোকের মতো থাকবি। This is on the third aspect which I want to address your lordship. Rest Millard I don't think is very important. Then therefore, Millard, the case is that first at the spot or where the agitation was going on, some police atrocities had happened. The second case is that in the police station, XYZ has happened. The result of XYZ in the police station is not apparent from the medical reports which they have filed. The third aspect of the matter is non-cooperation by the Midnapur hospital is not established prima facie because, Millard, there is no variance between the medical reports of Midnapur College as well as Calcutta Medical College. There is no variance. Only to make out a case where a second, Millard, medical treatment is made, and that too 6:52 in the evening. And, Millard, a stray comment about, Millard, the SC/ST Act. But these are, Millard, the basic facets of, Millard, this petition. Now kindly see, Millard, what is the legal position. First is, kindly have a look to, Millard, Alec Padamsee, Millard, there are a host of cases. I will not burden your lordship, Millard, with number of cases.
No, burden me. I'm ready for that today.
No, it's a well established, Millard. It's just one from our court, one from, Millard, the Supreme Court. But take a case, I admit this. But since it has fallen from the court, let us examine that also.
Because we are at a stage where there is no case. Court is also not thinking in terms of direction for registration of an FIR. But I'm not also thinking in terms of that. To throw away a petition, the only option left before this court now is to throw away the petition. Now, will it not be a denial to for access to justice?
Yes, I'll address your lordship immediately on that. Apropos the first submission, it is a throwing away of a writ petition. Go and avail the statutory remedies on the maintainability part. Apropos the second point on the alleged custodial torture, Millard, your lordship is not throwing away the petition. Your lordship is showing them the appropriate remedy. The appropriate remedy would be where evidence can be taken, he can establish his right and pray for compensation.
And so far as the issue relating to access to justice concerned.
But so far as access to justice is concerned, my lord, access to justice is in such case through the civil court or the criminal court. Access to justice for infraction of Article 21 in the public law remedy is an established infraction of fundamental right. Today, my lord, we are, my lord, at the stage of an allegation stage.
Not even allegation.
Take it, my lord,
Allegation.
allegation stage. We are not at an established stage.
No, we are not.
Therefore, my lord, prima facie also, but if these parameters which have been laid down are not apparent to the satisfaction of the court, prima facie, my lord, your lordship will not be denying justice or not be denying access to justice by relegating the petitioners before the civil court or the criminal court according to their choice. But access to justice does not mean access to justice only under Article 226.
This question I am just asking you only for the reason that the representation is, although you have your reservations regarding the issues, I am not taking that part. If the accusations are rightly, wrongly of custodial torture, let's say wrongly also. You said rightly, I say wrongly also. Now, in case the petitioner has approached the court with such a representation which was advanced, not considered, in none of the cases at the first instance they were thrown away. Whole of the judges.
I get you.
So the court considered everything and thereafter decided and came to the finding at a much more later stage, I would say. In fact, I think the High Court judgments are of division.
All after. No dispute on that.
So, in those cases, it can be presumed for the timing they were not at the first instance denied any, I don't say justice, access to justice. There is an accusation of violation of fundamental right and a party has approached the court for an access to justice. According to you, there are other avenues open. That's one of the answers. But then, is it not the duty of the court to ascertain regarding the truthful of the accusations concerned over here, sir? And then whatever comes up, decide, because decide the issue. That is what is going on through my mind. Otherwise, in a similar case, I would not have passed an order. There also, I have not said that register FIR and start investigation. I have not said that, sir. What is bothering me over here is also, we go access to justice is also encompassed within the Constitution.
Right. Article 21 itself conceptualizes access to justice.
Now, once a party to a litigation has approached this court, admitted part is this, up to this, nothing more than that. They were taken into custody, they were released from custody. I mean, to the police station. This part is not omitted.
Not disputed.
Not disputed by both the parties. They have come up with the accusations of certain issues relating to physical torture being inflicted upon them. They had made a representation, and such representation, obviously, as usual, is not considered. Now, is it that at the first instance, the High Court should throw away the petition?
Lord, on the second aspect. First aspect, Lord, I said the writ petition itself is not maintainable. Whether your lordship is going to dissect the relief and relegate a part to the through the normal statutory process, or Lord, relegate the writ petitioner in its entirety or on all reliefs to the respective courts, that is, Lord, it's the court's discretion. But ordinarily, Lord, courts would not or are not inclined to dissect the reliefs. If I succeed on the first point, I believe, Lord, the others should go along with that. But be that as it may, Lord, in respect of the second point, atrocity point, assuming the writ petition is maintainable. Where the greater discretion lies on the
I'm not an atrocity point, sir. Atrocity, you have shown you have your own points regarding an afterthought, factual circumstances. That's an acceptable part. Access to justice point.
yes, access to justice point what I'm saying, Miller. Access to justice is maintainability qua entertainability. I presume for argument's sake this is maintainable. The discretion lies with the court whether or not to entertain. That is now whether or not to entertain, assuming for argument's sake it is maintainable. To entertain, Millard, the parameters which has been laid down by the Supreme Court, in my very humble submission, has to be prima facie satisfied. Millard, please consider this, Millard, writ court is a discretionary remedy. When, in order to, Millard, invoke the discretionary jurisdiction by a 226 court, Millard, the burden is heavy or heavier on the petitioner to make out a case on the pleadings on the first day, at the first instance, at the first glance, that it requires a probe. I won't say probe because probe is possibly not a correct expression. Millard, a judicial review by the court. Millard, denying to entertain a writ petition in very respectful submission will not in all cases result in denial to access to justice. What is access to justice? But access to justice is to go before an independent forum and get the points of the disputes agitated, resolved, judged, enforced. Well, I give you a Lordship an example, but since the Lordship is thinking aloud. Well, this petition is entertained today. Certain directions are passed today. Tomorrow I come with a affidavit in opposition denying all the allegations. Bold denial. It becomes a disputed question of fact, especially cases of this nature. And a disputed question of facts, if it arises in a writ jurisdiction, it is not that it has to be always so now. The court will see whether from documents on record a disputed question of fact can be resolved on. My respectful submission is, Millard, if tomorrow I come up with an affidavit saying that everything is wrong, Millard, your Lordship would be handicapped, kindly not take me amiss, in deciding such disputed questions of fact on the basis of documents on record. Please consider this, Millard, because this has got a, some sort of a repercussion, Millard, for the future. Because my concern is more important, though his concern is not less important, but is that, Millard, this tendency is also to be looked at. Somebody taken to the police station comes out and says that I have been thrashed inside. This may become a trendsetter. Therefore, Millard, watertight cases, in my very respectful submission, only are to be entertained. Now, please consider, Millard, for the time being, where the loose ends or, Millard, the missing links. Burn injury, nothing before your Lordship today. It is not that nobody was aware of whatever has happened inside, because in the afternoon, Millard, their leaders went outside, inside the police station. The leaders were not prevented from, Millard, sending an email or going to the sending an FIR, going to the SP's office. No case went out. The leaders possibly waited. I do not know whether they had waited all along or not. Possibly waited all throughout till they were released, because when they came out, they found the leaders were over there to escort them to their respective homes. Leaders, plural. Now I go to the police station to lodge a complaint. I come out and say that the police has snatched my mobile. Very easy. That is why the Supreme Court uses the expression whether it is first is patent indefensible. I am saying it is defensible. These are the factors please consider. Number two. This is the first aspect. Leaders were there. No complaint. No contemporary complaint. 3 days. No explanation why they waited for maybe 2 days. Why for 2 days? Number two is alleged non-cooperation by the medical college at Midnapur. Comes.
Mr. Dotto, it's 1:32.
Yes, sorry.
I would like you to address on access to justice.
Very
Tomorrow 4 p.m.
well, only problem.
1:45 it is starting. After 4 p.m. nothing will remain there, sir.
The problem is, my lord, medical, why we are placing for at least a medical board, my lord, they were having injuries. And my lord, slowly, the injuries are, my lord, going away, my lord. That's why, my lord, at least at the medical board, at least they should have been appeared before a medical board. My lord, I'm not saying about SC/ST Act Commission, but my lord,
What you are saying is not more important. What is more important is over here the probability. I'm thinking in a different manner this case, and I have to balance between both the things what Mr. Dotto has said, and obviously
today
the
they are-
anxiety and agony for which you have approached
my
this
lord,
court.
my lord, my lord.
Otherwise, I would not have.
They are saying about access to justice. Question arises what they did from 6 to today's 12. What they did. Where is access to justice? My lord, 4 girls. They are admitting that those girls were left from the police station at 2:20. What they were doing inside the police custody? What they did? Any case has been started. Why 4 girls were taken away by police? All right, police did not do anything. But is it not shaking our conscience, my lord? Why police took those 4 girls to police station? Why they kept over there for 15
something
hours?
uncommon. It happens everywhere
Acha,
where
Is it not? It is common, and we shall support this because police they have tortured 4 girls.
No, normally it is expected after around sunset they should have been left out, sir.
Why they were kept inside the police
That is
station
an
for 15
issue.
hours?
Anyway,
That is an issue which your Lakshmi will address. No doubt about that.
I want to address, sir. He is appearing for. I'm whatever is in my mind. I'm allowing him to ventilate that, sir.
He was accompanied by one lady.
So let him complete. He has not completed. I will want him to address under these circumstances. This may not be one of the cases in a true set of facts or circumstances. Suppose you are arguing on the foundation that you are disbelieving the factual circumstances. There may be a true set of circumstances is also where there is no medical report also. A person has been thrashed. But then whether at the first instance, the writ court, if you have something authority or
Regarding
anything,
that, my lord, we have our answers. They firstly, my lord, when they were taken in the custody, there is no medical report, and that was the duty of police
But
to
I
take
would-
their
but I-
medical report.
but I would
Right,
request my
right.
friend
Allow me
to
half an hour.
confine himself through the pleadings. I have not gone
Yes, yes.
one
I
word
shall-
beyond the
I shall place.
Mr.
My lord,
Mr.
please kindly half an hour,
Yeah.
my lord, half an hour for us.
More than that, I will give you. More than that, I will. Since just because this is a balance of the court to be drawn, whether at the first instance,
Absolutely, my lord, absolutely.
whether see repeatedly entertaining the petitions will also multiply the cases. Number one. Number two, throwing away of the petition
Absolutely.
may
my lord.
increase the number of custodial torture.
Right, sir.
Yes, yes.
That is why I am on access to justice point. Whether at the first instance the High Court will not consider anything. Both. This is a very tricky
I bow down,
situation.
my lord. Yes.
That I'm not saying whether it has been done, whether it has not been done. Because all the cases which have been referred to were at a very final stages of the cases.
Right, sir. I quite appreciate.
That is why I come to the basic point: access to justice of the persons who approaches this court, balancing between where multiplication of. In fact, there are many cases also where in custodial violence was questioned also. There are also cases also that there is hardly any evidence in cases of custodial violence. Not possible for a person to obtain
My lord,
evidence.
absolutely. Like our case.
So let us say, Acha, learned advocate, a general um, continues with his argument and intends to continue with the same. Uh, on 19th of March 2025, released the petition under the heading Special Effects Matters at 3 p.m.
Let's go, madam. Great.